Colegas.
Dear colleagues, a very good afternoon. This is meeting 3238 of the Human Rights Committee. This is a public meeting which has been convened for the purpose of examining the 7th periodic report of Sweden, a country which regularly reports to our committee. I am delighted to extend a very warm welcome to His Excellency Mr. Per Olsen-Frid, who is the head of the Swedish delegation. This large and high-caliber delegation, which is with us this afternoon to engage in this dialogue. I'm also very happy to note that the state regularly supplies information to us. It responds to questions put to it. This is a state that heeds also the request for interim measures in individual communication cases. This is a very important point which deserves underscoring in view of the specific characteristics of those cases. It speaks to the state's good faith desire to comply with its obligations. Of course, the committee will also have grounds for concern. This is the case for all states. The members of the delegation already know, I'm sure, that the committee members are highly inquisitive individuals. They will ask questions, they will put points to you, and this is all part of the way in which the Human Rights Committee works. Let me say also that I personally am delighted to play host to Sweden, since Sweden was the very first country that I examined as a committee member when I joined the committee. The very first state that I examined in March 2009 was Sweden, so I have a particular soft spot for Sweden as a state. Let's get down to work. Allow me to give the floor to His Excellency Mr. Per Olsen-Frid for him to deliver his opening statement. You have the floor, Your Excellency.
Mr. Chair, distinguished members of the committee, dear NGO representatives, ladies and gentlemen, the 7th periodic report of the Government of Sweden was submitted to the committee on 13th of April 2015 under the new procedure with a list of issues prior to reporting. We would like to thank the committee for the list of issues and for welcoming us to Geneva today. First, let me introduce my colleagues. Jenny Olausson, Deputy Director General at the Ministry of Culture. Johanna Peiron, Senior Advisor at the Ministry of Justice. Henrik Sjölinder, Deputy Director at the Ministry of Justice. Johanna van Roy, Legal Advisor at the Ministry of Justice. Karin Stensson, Desk Officer at the Ministry of Culture. Emily Lindahl, Desk Officer at the Ministry of Culture. Erik Adel Hellström, Desk Officer at the Ministry of Culture. Kerstin Evelius, National Coordinator for Mental Health, Ministry of Health and Social Affairs. Karin Bengtsson, Desk Officer at the Ministry of Health and Social Affairs. Annika Romeus, Desk Officer, Ministry of Health and Social Affairs. And Hanna Seland, Deputy Director at the Ministry of Employment. Let me begin by reaffirming the commitment of the Government of Sweden to ensure full respect for its international human rights obligations. However, challenges remain before Sweden can comply fully and completely with its Convention commitments on human rights. The promotion and protection of human rights is one of the government's most important tasks and also constitutes a cornerstone in Swedish foreign policy. The new goal for the government policy on human rights is to ensure full respect for Sweden's international obligations on human rights. It will form the basis upon which the future systematic work on human rights in Sweden will rely upon. And this was recently adopted by the Parliament. In order to further strengthen the work for human rights, the government will deliver to Parliament a strategy for the systematic work for human rights in Sweden. And one important part of the forthcoming strategy is the proposal to Parliament to establish an independent national human rights institution in conformity with the Paris Principles. As a part of the government's efforts to promote and protect the rights of the child, the government has initiated the process of incorporating the Convention of the Rights of the Child into Swedish legislation. A public inquiry has been set up in order to propose a law on the incorporation of the Convention. This inquiry is planned to submit its result to the government this Friday, 11th of March. A new disability policy will be effected in 2017. And furthermore, last year, Sweden adopted a national action plan on business and human rights, as the sixth country in the world to do so. It is developed in line with the UN guiding principles on business and human rights, and it clearly states that the government expects companies operating in Sweden or abroad to respect human rights in all their activities. The action plan is part of the government's more ambitious policy on responsible business. Mr. Chair, the government reiterates its commitments to further advance the opportunities of the Sami people, to protect and develop the Sami culture and society, and to strengthen the Sami right to self-determination in accordance with the status as an indigenous people. As a consequence, the government intends to further increase the ambitions within this policy area, for example, by strengthening Sami influence and participation. Furthermore, in accordance with Sweden's statements to the Human Rights Council, the government will work towards a ratification of ILO Convention 169. However, a decision to accede to a convention is ultimately a matter for the Swedish Parliament. To secure the rights of the national minorities is an undertaking that the government has set to fulfill. Long-term results can only be achieved through close cooperation between agencies, local councils, and the national minorities themselves, and is at the heart of the measures that the government is taking. The government is currently preparing a review of the Act on National Minorities and National Minority Languages. Ensuring the human rights of Roma continues to be a priority for the government. Approximately €6 million has been allocated for further implementation efforts of the strategy for Roma inclusion during 2016 through 2019. Mr. Chair, Sweden has a feminist government. For a feminist government, gender equality is part of the solution to many of the challenges that we face in society. We are convinced that the gender equality is a fundamental matter of human rights, democracy, and social justice, as well as a precondition for sustainable and inclusive growth and welfare. We are firmly committed to making a difference in policy choices, priorities, and allocation of resources to reach gender equality. Recently, the government presented its action plan for a feminist foreign policy. The aim is to achieve concrete results to enhance both gender equality and the full enjoyment of human rights by all women and girls. One area where the Swedish Foreign Service will continue to be a driving force is women's and girls' sexual and reproductive health and rights. There is a need to continue to strengthen legislation on discrimination in order to be as effective and comprehensive as possible. This includes amending the rules on active measures in the fields of education and working life in the Discrimination Act to cover all 7 grounds of discrimination. The government intends to submit a bill to the Parliament on these matters spring this year. Mr. Chair, Sweden and Europe are in the midst of providing security and safety to people fleeing war, persecution, and oppression. In the worst refugee situation since the Second World War, the Swedish people are showing great solidarity. We stand up for the international right of asylum. In 2015, more than 160,000 asylum seekers came to Sweden, of which about 35,000 were unaccompanied minors. This makes Sweden one of the EU member states with the highest number of asylum seekers per capita. The number of children and young people arriving during the autumn of 2015 was so high that it was equivalent to more than 100 new school classes each week. Unaccompanied children have the same rights as all other children. Sweden takes an extensive responsibility for children in need of international protection and has the highest number of asylum-seeking unaccompanied minors in the EU. The government and the main opposition parties have agreed on a review of the entire situation concerning the placement and treatment of unaccompanied minors, including issues such as accommodation, legal representation, and interpreters. At the moment, we host over 180,000 asylum seekers in our system. The capacity of our reception system has thus been stretched, creating challenges within the field of housing, education, and jobs. We have a lack of school facilities and teachers, as well as healthcare and social services. Authorities and municipalities have warned that the important social functions cannot adjust to the current situation. It is at the utmost importance that the reception of newcomers remains dignified. In the recent months, the government therefore had to prepare a temporary adjustment of the Swedish legislation on asylum in order to secure a sustainable and effective reception system. A global crisis requires response built on solidarity and responsibility sharing, also within the EU. Sweden is committed to work for a new and sustainable asylum system in the EU based on a fair distribution system of all asylum seekers. In order to have an effective and solidarity-based refugee reception, all municipalities in Sweden must join in and take responsibility. Therefore, a new act on reception came into force 1st of March 2016. Under the new act, all municipalities can be required to receive new arrivals for settlement in the municipality based on their own situation and possibilities regarding labor market, population, and other reception services provided. One integration challenge is to make use of knowledge and skills of foreign-born people who live in our country or who have just arrived. The government has therefore introduced reinforced labor market-oriented measures, complementary education, and programs for validation of degrees and work placements. Mr. Chair, I regret to inform this committee that a number of asylum accommodations have been set to fire and others vandalized. It is fortunate that no person has so far suffered injuries from this. It is a priority for the police to ensure that the safety of asylum seekers as well as asylum accommodations. The police work closely with the migration agency who runs the accommodations as well as the municipalities on site. Xenophobic, racist, or violent extremist acts can never be accepted. They must be investigated in full and preventive measures must be taken. In recent years, the number of vulnerable EU citizens staying temporarily in Sweden has risen. The government has a profound understanding of the situation for these EU citizens, including Roma, when staying temporarily in Sweden without having the right to residence here. One important aim for the government is to work for an improvement of their living conditions in their home countries. It is important to have a long-term perspective on these issues. The government has therefore taken a number of initiatives, both bilaterally with Romania and Bulgaria and at the EU level. The national coordinator with the task of supporting the work being done by public actors in this field recently presented his report to the government, where he addresses the need for continued coordination of measures at the regional level with regard to vulnerable EU citizens. The government will now consider the report's proposals. The government has taken measures against the exploitation of persons in vulnerable situations, exposed to risks of forced labor, of begging, and to investigate exploitation of labor migrants. The police is giving priority to fighting trafficking, and a strategic decision was taken in October last year to lay the ground for improvements in the investigating ability and in the ability to assist and protect. A particular series of measures are also being taken in order to better investigate crimes against vulnerable EU citizens, including hate crimes. In order to address the underreporting of crimes from this group, the police will invest in outreach and information activities. Mr. Chair, the promotion and protection of equal rights and opportunities for LGBT persons remain a priority. The government is currently consulting on a proposal from an inquiry regarding stronger legal protection for transgender persons under criminal law. Mr. Chair, hate speech and hate crime undermine democratic values and run counter to the principles of the equal value of all people. Measures to combat hate crime, both within the judicial system and in other parts of society, are therefore a matter of priority for the government. A national plan against racism, similar forms of hostility and hate crimes will be presented by the government. The national plan will have a focus on racism in general, as well as different forms of racism, such as Afrophobia, anti-Semitism, anti-Ziganism, and Islamophobia. In March last year, the Swedish police reported the results of a government commission to develop its efforts to combat hate crime to the Minister for Home Affairs. As a result, the police is raising its ambition, combating hate crimes and other crimes threatening human rights and freedoms, such as the freedom of opinion and expression. One such worrying trend is the hate and threats that aims to silence journalists and politicians. The Swedish government will take action to increase awareness and develop preventive measures. Turning to the issue concerning an independent civilian body to investigate complaints against the police, the new Department of Special Investigations within the new single Swedish police authority has now been in operation for a little over 1 year. We share the view of the committee that this type of investigations must be conducted independently from all other police work. We strongly believe that the trust of the general public is key if the police is to perform its duties well. I'm proud to state that in the recent safety barometer, the trust for the Swedish judiciary in general is high, and the trust for the police is slightly on the increase from an already high level. Quality reasons, including access to a broad set of investigative skills, have led us to conclude that internal investigations should stay within the realm of the police. We ensure the independence by a budget completely separate from the police and by an appointment of a director directly by the government. The last report of the European Committee for the Prevention of Torture and Inhumane or Degrading Treatment or Punishment, based on its visit last year, concludes that the setting up of the new Department of Special Investigations has addressed most of its concerns, in particular the strengthening of the independence of the new department. Mr. Chair, under the instrument of government, all citizens and foreign nationals in Sweden are protected against torture. It's not possible to restrict this protection. In addition, the ban on torture in the European Convention for the Protection of Human Rights and Fundamental Freedoms has the force of law in Sweden. As stated in our report, in June 2014, the government appointed an inquiry to consider the need to introduce a specific crime of torture in Swedish penal law. The inquiry proposed, among other things, that such a crime should be introduced. Now, Mr. Chair, combating violence against women is a priority for the government. In order to reach the goal to end men's violence against women, the government is investing in measures to prevent violence. These measures involve, inter alia, violence prevention programs in schools, financial support to counseling centers for perpetrators, and treatment programs for offenders in the prison and probation service. Violence and abuse against women and children with disabilities have long been neglected. Even though there is still a general lack of data concerning the prevalence of violence against this group, public awareness in Sweden is increasing. Programs targeting violence against women and children shall always include a disability perspective. the government has allocated more than 10 million euros annually to women's shelter organizations, including shelters for women with substance abuse, women with disabilities, women trapped in prostitution, or human trafficking for sexual purposes. The government will present an update of the National Action Plan in order to protect children from trafficking, exploitation, and sexual abuse for the period 2016 to 2018. Strong legal protection against men's violence against women, including sexual offences, is of the utmost importance. The government has appointed an inquiry to review the penal code provision on rape and is considering including a consent-based regulation and negligence offence regarding rape. The review includes analysing the causes to why so few reports of rape lead to prosecutions and convictions, and considering measures to enable the judicial system to further improve its work in the area. Mr. Chair, in August last year, the government agreed upon a national counterterrorism strategy. One important principle in the strategy is that fundamental rights and freedoms and the rule of law must be ensured in all actions to combat terrorism. Terrorism in itself is a threat against fundamental rights and freedoms of our citizens, and in our efforts to counter its phenomenon, we must uphold and respect our obligations according to international law. Terrorism is an extreme form of violent extremism. To prevent and counter violent extremism and terrorism, it is essential to address norms, values, and attitudes that interact and contribute towards the growth of and recruitment to violent and political or religious extremist ideologies. The most comprehensive preventive measure is the National Coordinator to Safeguard Democracy Against Violent Extremism, who was appointed in 2014. The coordinator shall create awareness of all forms of violent extremism and ensure that preventive methods are developed on local and national levels. The implementation of an EU directive on the right of access to a lawyer will further strengthen the rights of suspects deprived of their liberty. A government bill is planned for spring 2016. Further, as of 2016, the government has asked the Swedish Prison and Probation Service to report which ways the authority is working to draw attention to human rights. The report shall include how the authority addresses criticism and recommendations as a result of international or national review. A public inquiry has been tasked with investigating what actions should be taken to limit remand periods and the use of restriction to mitigate against the isolation of persons on remand. In April 2015, the Swedish Prosecution Authority decided on new guidelines and regulations with the aim to reduce the use of restrictions for persons in pre-trial detention. The government has also asked the Swedish Agency for Public Management and the Swedish National Council for Crime Prevention to further study these issues. Mr. Chair, before I close, I would like to highlight the crucial role civil society organizations have played and continue to play in pushing for respect for human rights. These organizations have been given the opportunity to comment on this periodic report. We also welcome the submission of reports from civil society organizations and others to the committee. Finally, I wish to underline the government's commitment to the rule of law and to the promotion of the legal principles therein. The protection of civil and political rights constitutes a fundamental task for a state that adheres to the principles of the rule of law. On that note, I'm also ready to give a brief summary of a report, and therefore also myself and my delegation are prepared to answer any questions that the member of the committee may wish to ask us. Thank you.
Thank you very much, His Excellency. Bien, vamos a...
Very well. Let us begin at this point our interactive dialogue. Various colleagues have sought the floor, and I will give them the opportunity to speak, to raise points and ask questions. Before that, though, I would indicate that previously we had Mr. Christer Tellin from Sweden, who served on this committee until 2012. And I would like to just pay tribute to that former colleague on the committee. The first speaker on my list is Mr. Shani. You have the floor, Mr. Shani.
Thank you, Mr. President. I would like to warmly welcome the delegation from Sweden and thank it for the replies to the list of issues which constitute the 7th periodic report for Sweden. The replies were submitted on time. They are frank, they are comprehensive, they're informative. We often congratulate delegations that display on the committee adequate gender representation in their composition, but this time I'm not sure what I should say. Obviously, the government, this is a feminist government. Maybe in future cases we will make a mental note to ensure male representation, which is stronger. But I'm just kidding, this is very well done. And I also want, before delving into the issues that I will cover, I wanted just to react to the opening statement by the head of delegation and acknowledge up front that I and I'm sure my colleagues on the committee are very impressed with the way in which Sweden has addressed the migration crisis. And I think the fact that the number of migrants arriving to Sweden are the highest in any European country per capita. I think it's a very notable fact, which I think reflects on the national openness of Sweden and also on its real internalization of the highest values of universal solidarity. And I hope that Sweden would continue to display such generosity and to contribute to this regional, in fact, a very serious global challenge. Now, I will be addressing in my intervention today issues 1, 5, 6, and 7 of the list of issues. And we'll deal with another issue tomorrow. So the first set of issues deals with institutional and legal reforms that have been undertaken since the previous report was submitted to the committee. There is some degree, some of the more specific issues on the various reform measures will be taken up by my colleagues. So I'll be dealing at this point in time only with I will make some general remarks, and we will delve into more specific discussion of specific initiatives and specific institutions later on. Again, I would start with welcoming the fact that the Constitution has been amended in ways which are conducive to implementation of the covenant, and that give effect to some covenant proceedings, to some covenant provisions in some specific legal contexts. The big question that we have is to what extent is the covenant part of Swedish law in fact. We understand that it has not been incorporated into Swedish law, unlike the European Convention. We do realize that the covenant may be relied upon by Swedish courts by way of interpretation of Swedish legislation. The report does provide some examples with respect, I think mostly with respect to Article 27 of the covenant, which has been relied upon. But the question is whether other provisions of the covenant are being relied upon by courts. We will be discussing, for instance, Article 26 of the covenant, which is not paralleled in full by the European Convention. And it would be important for us to understand to what extent is this article and the case law of the committee on that article and the general comments on that article, as well as on other relevant articles. To what extent are they part of the legal acquis, which Swedish courts are relying upon when implementing domestic human rights legislation. So this is one specific issue that I would like to flag up front. The second, more specific issue, the report does suggest that the constitutional reform has introduced a right for trial within a reasonable time. Could you just provide us with some more information as to what would constitute a reasonable time? So this would be the second point that I would want to raise in this regard. More generally about awareness to our covenant, the question is to what extent are the various internal bodies within Sweden aware of the existence of the covenant, the contents of the covenant, and the case law of the committee? So it's not just the courts, whether local governance bodies are aware of the covenant, are they utilizing the covenant, are the various ombudsmen aware, do they have the legal power to rely upon the covenant in the work, etc. We will be discussing the 2009 Discrimination Act. This is a very important legal development, of course, which took place in Sweden. My colleagues and perhaps myself will return to it later and raise some of our concerns with regard to the interface between that law, the European Convention, the Covenant, and the specific authorities of the new Equality Ombudsman. But as I said, this is something that will be discussed later, as well as the interface between the Criminal Code prohibition on discrimination and the grounds for discrimination under the 2009 Act. We will also be discussing in that context the de facto existence of remedies for victims of discrimination. So this is just to flag a set of issues that will be taken on subsequently by my colleagues. Moving on to issue number 5, which deals with counterterrorism. And I would like to thank the delegation for the information provided to us in the report. Where I did not see a sufficiently precise information is on the issue of the number of detentions under the Terrorism Act. The report does suggest that there have been few prosecutions under the Act. If you have more specific information as to how few, it would be helpful, but we were concerned about suggestion that there is a gap between number of arrests and number of prosecutions, and for this we need to obtain more information. We acknowledge the various government communications which lay out the national counterterrorism strategy, including the recent 2014-2015 communication. And the basic approach that has been taken in these communications is that certain rights and freedoms may be restricted in law under certain specific conditions, so long as such restrictions are imposed in order to satisfy purposes acceptable in a democratic society. This is, of course, generally something that the committee would not object to, but of course the question is how this is actually given concrete effect in specific circumstances. And we would appreciate any information for follow-up measures that have been taken pursuant to these communications, which demonstrate the attempts by the government to strike a balance between human rights concerns and the need to provide public safety. And can you please specify, with regard to the National Coordinator's Office, which we have just heard about, to what extent does that office has a role in human rights protection? I mean, I do understand that that office has a role in coordinating government's efforts in the field of counterterrorism and in collecting information about violent extremism. But it's not clear to me at this point what is the role with respect to ensuring human rights protections, or maybe it would be other agencies of the state, of the Swedish state, that would assume that specific responsibility. Now, one significant issue that has been brought to our attention by civil society are concerned about what is called ethnic profiling, concerns that especially Muslims are being unfairly targeted in counter-terrorism related law enforcement and investigations. There are specific allegations that Muslims are more likely to be stopped and questioned by police. The judges would be less inclined to provide them with bail because they allegedly represent a higher risk of flight. I understand that there is no comprehensive, at this point in time, there is no comprehensive study on this issue, so perhaps some of the information that we have been receiving is more of an anecdotal nature. And the question to the government in this respect, to the delegation, is twofold. First, is the state party taking of its own some measures in order to study these sort of allegations and to ensure that these perceptions do not reflect what's happening on the ground? And secondly, and more importantly, is what measures are being taken in order to underscore for law enforcement officials at all levels the need not to engage in what the government communication itself has defined as the opposition to branding of persons on the basis of their ethnicity, of their religion. So again, we are concerned here with the implementation of government more than with the declared and stated government policy in this field. Finally, on anti-terrorism, we did see some press reports that especially after the terror attacks in Paris in November, there have been moves to introduce new legislation and take new measures in the field of counterterrorism. I'm not sure whether the bill on special criminal responsibility for travel falls within this category, or perhaps it was already in the making before that. But we would appreciate any information that you can provide us on what sort of initiatives or what sort of bills are so to speak, in the pipeline with regard to toughening or changing the equilibrium we discussed before between human rights and security. With respect to issue number 6, dealing with surveillance, this is of course a very difficult topic, and I do have some concerns which I would want to share with you and obtain from you your comments. First, with regard to data mining, it is my understanding that under the 2008 Act on signals intelligence, the Forsvarsradioanstalt, the FRA, thank you, has the authority to engage in data mining. The question is what sort of legal supervisions are available to ensure that this authority is not being abused. For instance, does the Foreign Intelligence Court need to authorize the exercise of data mining? If not, what other safeguards are in place? And would the court be ever involved in data mining cases? Would the privacy protection representative be involved in such proceedings? The difficulty, of course, is because data mining is such a general measure that it is actually hard to identify in advance the individuals who may be directly affected. So it is hard. We want to get a better understanding of what safeguards would be put in place. For instance, would the Data Inspection Board have a role here? Would the Parliamentary Ombudsman would have a role? Would the Chancellor of Justice have a role? And do you have any information that you can share with the committee as to what sort of data, when we are talking about data mining in the context of the exercise of authority under the Act, what sort of net is, how broad of a net is being actually cast or potentially being cast? Is there anything, for instance, that would stop the FRA from monitoring all telecommunications crossing Swedish borders? And specifically on data mining, what sort of safeguards are there with respect to data sharing with with foreign intelligence agencies? Are any decisions of the court or the Data Inspection Board published in this regard? Now, I do understand, and I'm heading towards closure of this question. I do understand the Swedish Commission on Security and Integrity Protection may check on surveillance activities if an individual believes that he or she are subject to covert surveillance. But the question is, how would an individual be in a position to suspect that he or she would be subject to covert surveillance? And in actuality, can you provide us with information as to how many such requests have been submitted to the Commission on an annual basis, or whatever information you have in this regard would be helpful. And finally, on this point, I would appreciate if you can explain to us what has been the exact nature of the changes that have been introduced after the entry into force of the 2010 Police Data Act, and to what extent are these changes consistent with Sweden's international obligations in the field of protecting the right to privacy. Very briefly on issue number 7, and this is the last point I'm going to raise today. Issue number 7 deals with the question of rendition and detention program. And here I acknowledge the answer by the Swedish delegation that there are no pending cases of that nature between the Swedish authorities, and I do not plan to pursue this matter any further. I will, however, ask a general question on the implementation of our previous concluding observations, paragraph 16, which dealt with the issue of special assurances. And we have asked the state party to exercise the utmost care in the use of such diplomatic assurances and to adopt clear and transparent procedures allowing review by adequate judicial mechanisms before individuals are deported, as well as effective means to monitor the fate of the affected individuals. So what I would actually want the delegation to provide us at this point is any information on the implementation of this specific recommendation made by the committee, not in connection with necessarily with the rendition issues, but more generally with respect to the reliance upon diplomatic assurances. So I thank you very much for your attention, and I look forward to hearing your responses in due time. Thank you, sir.
Muchas gracias.
Thank you very much, Mr. Shani. The next speaker on my list is Mr. Nigel Rodley.
Thank you very much, sir. And I add my own words of welcome to this distinguished delegation, or welcome back in my case, as yours. As somebody who spent longer than one might have hoped working in lockstep with the government of Sweden at the time of the drafting of the Torture Convention, it's always particularly pleasant to engage with a state party whose basic commitment to fundamental human rights is beyond question. That, combined with the fact that just about everything of concern to me is under study at the moment, means that there's a somewhat elusive target here to ask focused questions on. So, for example, right at the beginning, I'm going to be dealing with issues 2, 8, and 9. 2 relates to the question of reservations and their withdrawal, and we're encouragingly told that the government intends to return to the Riksdag, forgive the pronunciation, with a strategy for systematic work on human rights in Sweden. One important issue in the coming strategy is to illustrate how to ensure independent review of compliance with human rights, and a new review of the reservations will be presented as part of the work on drafting a strategy. So paragraphs 19 and 5 together of the report. Is there anything more to be said? What actually is going to be sent to Parliament? When? Is there any specificity at all? What kinds of studies are there going to be before that? How far will there be studies, either by the government or independently, of the need for a reservation, say to Article 10, Paragraph 3, relating to the general obligation to segregate juvenile offenders from adults in detention, or regarding double jeopardy in Article 14, paragraph 7, or regarding propaganda for war under Article 20, paragraph 1. Are there any preliminary indications of its intentions in this regard? Moving on to issue 8. Since the list of issues, and indeed it was confirmed by the introduction from the distinguished head of delegation, there is now, it seems, going to be a law against torture, a specific law against torture. It would be helpful to know if there can be any elaboration of that. Do we know what the outlines of and the contents of such a law will be? Will it, for example, follow closely the prohibition contained in Article 1 of the UN Convention against Torture? A related issue is the issue of statutes of limitations, as indeed raised with the delegation by the Committee Against Torture. Until now, like some other countries, and it's still the situation, Sweden relies on such laws as assault and aggravated assault that are subject to statutes of limitation, and indeed that's one of the criticisms of the present legal system. Can we be assured that the new law will also address the statute of limitations issue and ensure that if it can't necessarily be a total elimination of any statute of limitation, that any statute of limitation be one that is no shorter than that of other grave crimes, recognized as grave under international law. Moving on to issue 9, sir. The responses regarding our questions are useful in terms of access to a lawyer and so on, as would be expected. It is, however, drawn to our attention that there may be problems of compensation of lawyers to the extent that they may not be sufficiently compensated to do the kind of diligent work that may be necessary in detention cases. We've also received, the committee has received information that patients in forensic psychiatric care are at risk of being subjected to illegal detention due to reasons of lack of available accommodation. It would be useful, I'd be grateful if we could know from the state party how far this is indeed a problem and what is being done to resolve it to the extent that it is a problem. Question of contact between pre-trial detainees and the outside world. Well, there's probably first of all an underlying question of the length of time of pre-trial detention. I understand there's no limit in Sweden for pre-trial detention, and that some detention has, pre-trial detention has gone on for as long as 4 years. I'd be very grateful for some encouragement that this is a problem that is also going to be addressed with some urgency. The course, the longer people are held in pretrial detention, the harder it is for them to remain in contact with the outside world. Finally, in relation to this issue, but it arguably, well, we'll leave it at this issue, paragraph 9 and our reiterated request for information regarding the possibility of establishing an independent civilian body to investigate serious complaints against the police. Now, the list of issues, the response to the list of issues, the report in paragraph 61 says that the committee to which the issue has been referred is to report by the 30th of April 2015. And so I'd be grateful to know what the outcome of that report was in terms of supervision and indeed more than supervision, a forum for complaints, an independent forum of complaints relating to police misconduct. Or is it envisaged that the proposed National Human Rights Institution, which was referred to in relation to issue 1 and which was referred to in the introduction by the distinguished head of delegation, would be the body that would undertake that activity? In the end, the general concern is a concern that the institutions, big institutions generally, and the institutions of government in particular, are not well suited to ensure that they comply with their mandates, or at least with all aspects of their mandates. And certain pressures to deliver on certain goals may sometimes lead to cutting of corners in terms of the methodology used to achieve those goals. I don't really mean to talk in euphemisms. It is a bit surprising, I guess, to find that indeed of all countries, Sweden doesn't have an independent complaints body for police complaints. So I'd be very grateful to know what the outcome of the study in the report of the 30th of April has been, and what follow-up there's going to be to it. Thank you very much. So I look forward to the responses.
Muchas gracias a usted.
Thank you very much, Sir Nigel. I will now give the floor to my dear colleague, Ms. Jelic.
Thank you, Mr. President, and good afternoon to everybody. I would also like to welcome the distinguished delegation of Sweden and to congratulate for the state replies to the list of issues of the committee. On behalf of the committee, today I would like to ask you in more specific about the issue number 3 of the list of issues, as I have several follow-up questions after reading your replies. And tomorrow I will be addressing several other issues. So thank you very much for emphasizing that the new Discrimination Act stipulates more grounds for discrimination, giving more space for covering more areas of society entitled to the protection against discrimination. It is important that amendments of the Act from 2013 and 2015 additionally extended the protection against discrimination on the ground of age and disability. However, still it is not explicit if the protection against discrimination is actually more effective after the new Discrimination Act and its amendments entered into force, having in mind that no data on cases or relevant statistics were shared with the committee so far. In this regard, I would like to invite the state to send us relevant statistics on discrimination cases, especially those in which the Equality Ombudsman established discrimination. I'm asking this because from your replies in paragraph 25, it is not visible how many cases were reported to the Equality Ombudsman, so for the committee to be able to have the whole objective image concerned. Also, it would be appreciated if you could provide yearly statistics for the indicated period of 2009-2014. We are able to find only the statistical data from 2014, which reads that out of 1,949 complaints on discrimination, the Equality Ombudsman took only 25 to the court. What is the reason for such a small number of latter cases? Is it connected with insufficient human and financial resources for the Equality Ombudsman work? Please, if you can elaborate on that, it would be useful. And also the role of the Equality Ombudsman concerning the promotion measures were estimated to be an important part of the work to prevent and combat discrimination, as it is stated in paragraph 20 of the state replies. In addition, it should be stated that it also has a specific mandate to enforce the Discrimination Act and the litigation power on discrimination cases in the court. Consequently, please can you tell us what measures have been undertaken in regard to anti-discrimination promotion, as well as to the prevention and combating discrimination? The committee was informed that Equality Ombudsman does not have competence to pursue discrimination cases on the basis of the European Convention on Human Rights, although it constitutes an incorporated part of Swedish law, as it is part of the acquis communautaire. In respect to discrimination, this might be problematic because it seems that there is no provision on general prohibition of discrimination in society in Swedish Discrimination Act. So that leads to the conclusion that general prohibition of discrimination as stipulated in the Article 14 of the European Convention on Human Rights could not be enforced by the Equality Ombudsman. I appreciate that the state replies, particularly in paragraph 23, it is reported that in June 2014, Government Inquiry Chair presented the proposals regarding active measures to be more effective instruments for preventing discrimination and achieving equal rights and opportunities. Since it is generally described in your replies to the list of issues, please may I ask you to explain to the committee if the above-mentioned proposals, which had been processed to the government offices, if they were accepted or adopted in the meantime, and if so, what have been the concerned results? I'm asking this particularly because the inquiry was supposed to present its report by 18th December last year. In regard to your reply on the committee's issue number 3B, please can you provide the committee with more precise information on what was done in concrete concerning establishing an independent national institution with a broad human rights mandate with adequate financial and human resources? The committee was informed by the civil society that there were discussions on the nature of prospective new independent institution for the protection of human rights in Sweden. It is important that such an institution is established under the Parliament umbrella, I think, and to be responsible only to the Parliament, not to the government, in order to be independent and not subordinated to. In your reply, as indicated under A1.5, the state described the government's intention concerning strategy for systematic work on human rights, as Sir Nigel mentioned. I would appreciate if you, in your further replies, could address the present situation in regard to the establishing phase of the institution. Finally, let me thank you in advance for your replies that I'm looking forward to.
Muchas gracias.
Thank you very much, Ms. Jelic. I would now like to give the floor to Mr. Fatala, please.
Mr. Chairman, and I would like to join my colleagues and welcome the delegation in Sweden and to thank the Swedish government for the detailed replies to our issues and to thank also the the, 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 the leader of the delegation for his detailed presentation. I would deal this afternoon with issues 4, 12, and 13. Issue 4 is related to the implementation of the committee's concluding observation. The reply of Sweden is reflected in paragraph 27 to 30, and in paragraph 27, Sweden stated that one way of following up observations and recommendations is to consider the need for an action plan. Here I have three questions. The first one, because you stated that there is one way to follow up. What are the other ways of following up observations and recommendations? The second one, that I can see from the language of your reply, that the action program is concerning the action program, it is too flexible because you use the term consider the need. Is there any criteria used to see if there is a need or not, and what are these criteria, and how you can evaluate if there is a need or there is no need for such plan? The third question, what is the role of the civil society, if any, concerning all the issues of implementations of the recommendation? In your reply in paragraph 28, I understood from this reply that if the committee found that the complaints right have been violated, analysis is made of what action may be taken by the authorities in Sweden. This would mean, at least my interpretation, that such action may be different from the action recommended by the committee. You know that in all the complaints we have recommendation, action to be taken by the government. But if when you assess yourself, can you have in your assessment another recommendation different from our recommendation? In paragraph 29, you stated that the observations are published on the government's human rights website. What about the publication of the follow-up made by the government, including the action program? Is this also published in your website, and other also comment and recommendation of NGOs or the committees and so on? In paragraph 30, reference is made to, and I quote, exceptional grounds against granting residence permit. What are these exceptional grounds? At least give examples. Turning now to issue number 12, related to non-discrimination and rights of non-citizens. I appreciate the reply reflected in paragraph 69, giving the ombudsman or any non-profit organization the right to bring legal action on behalf of individuals. My first point is related to information received by the committee that the ombudsman does not have the power to pursue cases of discrimination on the basis of the European Convention on Human Rights, and this was already raised by two colleagues, which, in accordance with paragraph 67 of your reply, has the force of law in Sweden. Please explain. The second point I'm raising, the committee would like I would like to raise, also the committee would like to raise, is related to the financial resources of the ombudsman. Do you think that such financial resources are sufficient in order for the ombudsman to pursue the cases brought to its attention? As mentioned by my previous colleague, the committee is raising this question because reports show that in 2014, the ombudsman was only able to deal with 25 complaints out of 1,949. Reports also demonstrate that similar financial problems faces the 16 local anti-discrimination officers. Please explain. Information which came to the attention of the committee shows that only a few cases of physical attacks on migrants have been prosecuted. Please provide information on the measures taken to prevent, combat, and criminalize hate speeches against migrants, as well as the number of prosecutions compared with the number of reported hate speech incidents, and also provide information of reported hate speech incident and information on most recent figure reflecting such cases, because to our information the police is taking action, but the one who is really the key person is the chancellor of justice, and to our information that he doesn't take any action in this concern. Uh, and I would like also to make a reference to a point which was also raised by my previous colleague, is the issue of refugee. We know very well in the committee that you have the highest per capita ratio of refugee in the EU. You are the first EU countries to receive refugee, but here I have several questions to be raised. First of all, we got reports, at least it was in the media yesterday, that Sweden is planning for the expulsion of 60,000 refugees, and in some statistics they say 80,000 refugees, which came to Sweden from countries where no war or conflicts are taking place. Also, that this issue of in this issue of refugee, there are some problem concerning, and I want just to refer to speech that in the presentation of the head of delegation today, he stated that in recent months the government therefore had to prepare a temporary adjustment of the Swedish legislation on asylum in order to secure a sustainable and effective reception system. Also, that there is a role of, as I understood also this afternoon, there is a role for all municipalities which can reply to receive new arrivals and to settle them and so on. Therefore, I would like to understand if there is a shift on the policy of Sweden concerning receiving the refugee, the treatment of refugees, the issue of reunification of families when there are children, the issue of sending back children who has no parent in Sweden, and so on. As for 12B, my question is what action has been taken by the government vis-à-vis the recommendations identified in the Afrophobia report on discrimination and racism against Sweden, and what measure has the government taken to redress discrimination against Muslims in the legal and welfare sectors, and also redress for the victims, a subject raised by the committee in 12B, but I was not able to find any answer to this in the Swedish replies. And here also I would like to refer to what was stated by the head of delegation this afternoon, that a national plan against racism, similar forms of hostility and hate crimes will be presented by the government. The national plan will have a focus on racism in general, as well on different forms of racism such as Afrophobia, which I refer to, anti-Semitism, anti-Ziganism, and Islamophobia. If we can have an idea about, if it is allowed to have an idea about this national plan, although it is not yet adopted, but at least to give us an idea that there is a serious change in the position of the government concerning all these issues I raised. And finally, concerning issue 13, related to the Roma community, the committee appreciates the replies reflected in paragraph 74 to 82 and would like to refer in particular to the coordinated long-term strategy for Roma inclusion 2012-2023, and in this regard refer to what is stated in paragraph 75, and I quote, the government has set aside some SEK 60 million for the strategy 2012-2015. Please brief us on the concrete results of the implementation of this short-term strategy, I mean, which ended already in 2015, less than 3 months ago. Thank you, Mr. Chair.
Muchas gracias a usted.
Thank you, Mr. Fatala. I would now like to give the floor to Olivier de Frouville. You have the floor, Mr. de Frouville. Thank you, Mr. Chairman. I, in turn, would like to extend a very warm welcome to the delegation of Sweden. I thank the head of delegation for the very comprehensive introductory statement. Allow me also to reiterate the compliments extended to the delegation by the colleagues who spoke before me, particularly with regard to the issue of refugees, which we will be coming back to in due course. I would now like to focus on two issues, issue 10 and 11 from the list of issues. For the former, these relate to allegations of police violence and the use of excessive force by the police, and for issue 11, the use of electroshock therapy. On the first issue, I'm grateful to the delegation for their replies, but I would nonetheless like to seek some additional points of clarification if possible. The State Party explains in paragraph 64 of its reply to the list of issues that the number of complaints lodged annually about the use of force by police officers in the course of their duties varied from 709 to 891. However, the state indicates that over the same period, the number of cases leading to criminal proceedings varies between 4 and 9. So 709 to 891 complaints and 4 to 9 prosecutions. Perhaps it's an optical illusion here, but this seems like a somewhat disproportionate difference between the number of complaints and prosecutions, and I would be grateful if the delegation could kindly shed some light on this. In paragraph 65 of the replies, the State Party explained that according to the prosecution authority, the most common sanction was day fines. But there were also some suspended sentences, very few prosecutions, and where those did take place, extremely light penalties. I wonder if you could kindly explain what a day fine is. By the way, I don't entirely understand what a day fine is, what that entails. So we have few prosecutions, light penalties, and with that in mind, I wonder if there are some causes for concern. Might the infrequency of prosecutions and the light penalties be sending out a negative signal and in some way guaranteeing impunity for acts of police violence? This concern is further accentuated by the fact that, at least according to information that we have received, and you will tell me if these are corroborated by your figures, the number of violent deaths at the hand of police has increased significantly in recent years. between January 2013 and May 2014, 7 persons are alleged to have died as a result of the police making use of their service weapons, compared to 1 death per year over the last decade in the same circumstances. And again, in terms of the punishments for this, it seems that only one of these cases led to prosecution and a conviction. The others led to acquittal. So it seems that there might be a latent problem of impunity. I would raise the issue of Mr. Sentu Selvarajah, aged 28, who was arrested after a psychotic crisis attack. The health authority called the police, but Mr. Selvarajah at that point had calmed down to an extent. This did not prevent the police officers on the scene from using tear gas against him and for covering his mouth with a plastic bag and using an extremely dangerous immobilization technique, which involved forcing the individual onto his knees and cutting off his breathing, leading ultimately to this gentleman's death soon after the police intervention. Is there a risk of such violent practices being repeated? Are there any measures in place to prevent the recurrence of such activities? You mentioned in paragraph 62, the review of training techniques in view of jurisprudence, and I wonder if further work is needed to review police training to ensure that such restraint methods that are highly dangerous are never used. In paragraph 63, here we have another problem with regard to techniques employed by law enforcement officials. This is not isolated to Sweden. Here we have a debate which arises in various European countries, but it's the use by Swedish police forces of expansion bullets, which have been banned by the 1999 Hague Convention. I have a question as to the use of those types of munitions. There are some arguments in favour of the use of those. There's reference to the avoidance of collateral damage with bullets that could go too easily through the human body and affect innocent bystanders. We also know that this type of expansion bullet can cause disproportionate injury to the human body vis-à-vis the intended immobilization purpose of the bullet. So do you feel that the avoidance of the risk of collateral damage really justifies the disproportionate injury in addition to the target which is intended? To take a specific example, and a well-known one, I think, I would take the death of Daniel Franklet-Muir in 2005. It would appear that this well-known case is directly connected to the use of that form of munitions. Lastly, issue 10, a question on issue 10. In paragraph 63, you talk about the recent implementation of a Swedish prosecution authority. You mentioned it again, moreover, in your introductory statement. This new investigative authority within the Swedish police authority, I do understand the notion of internal procedures and investigations, but I would like to know a little bit more about the procedures involved. Is it simply an internal investigation authority? Is it a prosecution authority? May prosecutions be brought by this body? Do they end up in the judicial system? Or is this purely a disciplinary body internally? I'd like to learn a little bit more about this authority because I'm not entirely clear as to how it operates. You make reference to the Committee for the Prevention of Torture, the Subcommittee for the Prevention of Torture, rather, and it concluded that the implementation less than a year ago of this new body responded to most of the subcommittee's concerns. But in the same paragraph, the committee expresses further concerns, and I quote,
"Remains an open issue whether the new department will also be perceived as independent by the general public, given that it is still formally a part of the Swedish Police Authority. Therefore, the committee reiterates its recommendation to reconsider the need for the investigation of complaints against the police to be entrusted to an agency which is demonstrably independent of the police." Donc, en fait,
So in fact, the committee is expressing a degree of satisfaction, but nonetheless expresses ongoing concern as to the independence or lack thereof of this institution. This brings me to the end of issue 10. Mr. Chairman, I will be briefer. Moving on, looking at the time, the committee had asked the state party to supply information as to the use of electroshock therapy in psychiatric institutions. This is issue 11. And the existence of appropriate monitoring and reporting systems, since there have apparently been allegations to the effect that this technique may have been used in an inappropriate way without proper oversight. I have read the government's reply. I thank the state party for the reply that has been furnished in paragraph 66 of its report. I do have to say, though, that this begs a degree of further clarification. The state party indicates that the Health and Social Care Inspectorate is a supervisory authority and is responsible for the supervision of all healthcare services. That's fine, but it doesn't indicate whether this authority has a specific mandate with regard to electroshock therapy in particular. What, if any, role and how is this role played? And if this body has a mandate to operate, has it taken measures to control the use of this therapy, which is potentially harmful? The state party indicates subsequently that the government has commissioned the National Board of Health and Welfare to propose how the National Patient Register can be supplemented with treatments performed by professional groups other than doctors. In 2014, the board submitted material in the matter that will be used to draft legislation. This gives rise to some questions. Your reply leads to further questions. Why focus specifically on treatments performed by professional groups other than doctors when it comes to electroshock therapy? Does that indicate that treatment may be ordered and carried out by somebody other than the doctor? That in and of itself poses problems with regard to oversight. What about treatment if undertaken by doctors? In that instance, is there a form of oversight? What is the nature of the proposal made by this board in 2014? I would like to learn a little bit more about that. The state party also talks about a bill. What is the status of that bill? Can you indicate the extent to which this bill addresses this issue, this concern on the part of the committee with regard to the potentially uncontrolled use of electroshock therapy for psychiatric purposes? On that note, I would like to thank you in advance for your replies. Thank you, Mr. Chairman. Thank you very much, Mr. de Frouville. This brings us to the end of the first cluster of the lengthy list of questions. My apologies, not entirely. I noticed that Mr. Muhamusa had sought the floor. I'm sorry, sir. You have the floor, Mr. Muhamusa.
I'm sorry to have to come in at this late hour, but I would like also to thank the the State Secretary and his delegation. A couple of weeks ago, I think just a week and a half, on 28th of February, we joined the world in remembering the late Alf Palm, our Prime Minister. And he gave us an example of how a just and democratic society should be, perhaps a little utopian, and unfortunately, the assassin saw through that and cowardly ended his life. One of the favorite quotations is that don't forget that when we open our arms to the persecuted of the world, we not only make permanent friends, we not only enrich our own culture, but we also help change the fate of these countries under authoritarian rule. And for the most part, Sweden has lived up to that kind of ideal. Yet a few days ago, a panel appointed and supported by the United Nations made some findings regarding one of known personality, Julian Assange, said that he probably should be freed, and but your country continues to not be helpful, at least not in the line of this hope that was espoused by the late Prime Minister. Do you see yourselves making, along with the United Nations and all who would like to see Julian Assange freed, to make it possible to the extent that it lies within your jurisdiction? I thank you.
Bien. Muchas gracias.
Thank you very much. As I was just saying, we will now set a few minutes break so that the state can organize their answers to the questions that have just been asked. We'll come back at 4:50, that is 10 to 5. So we adjourn for the moment.